This is a fascinating time for design professionals. New technologies and project delivery systems are changing the practice of architecture and engineering. Although true integrated project delivery projects, IPD projects, with total risk and reward sharing between the owner, the architect, and the contractor are rare, early and increased project collaboration is undeniably on the rise. Building and information modeling, BIM, including Revit-enabled IPD, continues to unlock new possibilities for creativity, synergy, and efficiency. However, these transformational forces present significant risks for design professionals who freely share their digital data but rely on outdated contract forms. And if this sounds familiar, you're not alone. One prominent architect recently told me that his firm completes BIM models and transmits them to contractors who essentially redesign the project. This is common today. However, it overlooks that design professionals remain liable for the completed design. Another architect recently told me that his international design firm struggles just to keep up with the curve in implementing BIM technology. His focus is getting the job done. Best contract practices and loss prevention are, as with most architects, not at the forefront of his mind. The risks of digital practice go beyond the blurred lines of responsibility for design. Less obvious is the risk that a contractor may rely on part of a BIM model that is later redesigned. Unless the problem is detected before construction, that mistake might give the claimant owner for extra costs and delay. Now, historically, these claims were simple to resolve. The design professional was only responsible for what was embodied in their stamped and sealed printed documents, and if the contractor relied on something else, it was generally the contractor's fault. But who's responsible if a contractor relies on an incomplete BIM model element and purchases a long lead time item that is eventually eliminated from the final design? What if it was the engineering subconsultant who was working underneath the architect that sent the incomplete model element to a subcontractor working under the general contractor? Who in that case is responsible for the extra costs of the long lead time item? The owner, the architect, the engineering subconsultant, the subcontractor, the general contractor? What if a similar design miscommunication injures a pedestrian passerby? The old contract forms that we use today don't answer these questions, but judges and juries and arbitrators are going to have to grapple with them for decades to come. And it's this disconnect between old ideas and new technologies is what led the AIA to introduce a new set of digital practice documents in 2013. They provide project participants with a framework for the transmission, use, and reliance on digital data. This is the C106 Digital Data Licensing Agreement, the E203 BIM and Digital Data Exhibit, the G201 Project Digital Data Form, and the G202 Project BIM Protocol Form. Now, these digital practice documents cannot completely eliminate the risks that are inherent in digital practice, but they can help design professionals and their insurers understand the risks by understanding and managing them. Now, I have it on good authority that the AIA is revising these 8-year-old documents, and I will be excited as a liaison to the Contract Documents Committee to put in my 2 cents. But it's not likely that the revision is likely to be a panacea. They require a lot of buy-in from owners and architects and contractors and all the project participants that is not likely to be forthcoming in the next few years. I do think, though, that design professionals and the owners that employ them ought to get familiar with the AIA's digital practice documents, the ones that were issued in 2013. They should keep their eye out for the new ones that are going to be released in a few years to try to understand where the industry might be going. Because I do think that if we fast forward 10 years, the sort of regime that is envisioned by these digital practice documents that the AIA has released, and there are other contract document providers that have similar documents. The regime that is contemplated is something that I think is likely to take hold and govern for most of the future, but not in the next few years because they are complex and they require so much buy-in from parties who don't understand them at this point. Setting aside the theoretical, though, unless you have an owner who's willing to insist that the digital practice documents become a part of the project and permeate through the entire web of construction contracts, in the short term, if you're an architect or an engineer and you are being asked to turn over your digital data, you're probably going to need to think about some sort of a custom form, a digital data release form, something that various parties might sign, indicating what are the permissible uses of the data, what are prohibited uses, releasing the design professional from any liability or claims that may flow from the misuse of those documents by third parties, and providing appropriate defense, indemnification, hold harmless, and other terms in order to protect the design professional in the short term. That's, I think, the too light end of the spectrum, and the digital practice documents regime is the too heavy end. I wish there was a Goldilocks happy middle, but I am pleased to report that contract documents providers like the AIA and similar groups are engaged in thinking about how design professionals should consider the risk of the way that we use and transmit and rely on digital data these days to take advantage of these new technologies in project delivery systems. And as the contract documents and the judge-made law evolves, I do think that we will be able to close the gap between the very theoretical digital practice document regime and the too light release form that we have right now, and find something with a happy middle to protect everybody involved in design and construction projects, so that their expectations can be met and so projects can be delivered successfully without claims.